Greetings, 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 greetings. It is I, King Clifford Jefferson, a citizen of Godfrey the Fifth kind of Anjou, the son of folk, the ruler of Jerusalem. It is January the 31st, 2025, which is equivalent to the birth year 2975. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of Archbishop Belmont from the House of Belmont. I greet you in the name of my ancestors, our predecessors, which we are the successors of. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Tip English Church of England as King Edgar, the Vicar of Christ, or Melchizedek, known as the King of Righteousness. I have another marvelous lecture for you today, and this one is titled American Revolution to Bar Entail and Enslave the English Heirs. Once again, the American Revolution. The focus of the American Revolution was to bar entail and enslave the English heirs, i.e., those who are misnomer as Negro. Okay? Negro, black, colored, Ethiopian, etc. Okay? If you watch my last lesson, the Negro, the Berbers, we are all Berbers, but unfortunately, names were denoted to us based upon characteristics, which simply means the color black. Okay, so once again, I want to give honor to the ancestors that allow us to be able to not be so emotional about this, but to just look at it, and be responsible as one should be in regards to searching for the truth. Okay, very important. So, with that being said, I want you all who is going to be listening today, who are of Negro features, all right, to understand how important it is to realize that you do have an inheritance, okay? You do have an inheritance. You did have an inheritance, but it was taken away from you, and it's only up to you to take it back, okay? And the only way you can have an inheritance is due just sanguineous, by blood, not just because you're born on the soil, because being born on the soil does not make you a citizen, okay? Being born on the soil does not make you a citizen. Okay, being a citizen is affiliation with the government that protects you. The United States or the states of any state is not a nation, nor is a government. It is a corporation. Okay, and being citizens or subjects of a corporation, you are subject to that law. Okay, very, very important. All right, so whether you choose black, negro, nigger, negra, negrito, negron, whatever complexion that you choose to throw upon those terms, you still first must meet the first requirement, and that's genealogy. Because we know in Ray Ahmad Hassan, it spoke about how the forefathers interpret citizenship based upon the meaning of the Naturalization Act of 1790. Okay, and based upon that conclusion of the court, that based upon how they identify citizen was based upon the color of skin. And in way Ahmad was not considered a citizen in the meaning of what they call the Naturalization Act of 1790. Then you come with the 14th Amendment, which was created for those who were newly emancipated by way of the 13th Amendment. That was supposed to be construed based upon United States versus one Kim Ark in lieu of the common law of England, not based upon some naturalization process that was established as an alternative to those who were protected by the 14th Amendment. Okay? It's very, very, very important. We know that when our ancestors, through the Reconstruction era, we were forced to fight in a union led or formed by Abraham Lincoln, the one responsible for emancipating us. But that emancipation came with certain conditions. This was the Confiscation Act of 1862, which I talked about in my last lecture. But, it's very important to understand that now all of us were slaves, okay? Now, all of us were slaves. Some of us were free people because they remember who they were. We know that the word Negro is a word or a term that originated in Castile. Okay, and Castile is over on the territory known as Spain, which is the Iberian Peninsula. Okay, and the people over there on the Iberian Peninsula, known as Spain's, were actually known as the Hispanio Visigoths, which was nothing more than Berber tribes spread out abroad. Okay, and they were constantly, like we are constantly trying to maintain our identity as Berbers, now known as Negroes, as we see in the North Carolina Act of 1740. Okay, Section 4. All right, they refer to the ancient Berbers as the Negro. Okay, the ancient Berbers as the Negro. You are all descendants of the Negro, the ancient Berbers, which were living not just here in North America, all right, but as well as on the Iberian Peninsula, as well as in the North of Africa, as well as in what the territory they we know that's called Great Britain. Okay, we must respect and honor and obey what it is that our forefathers, our foremothers, our children, uh, who gonna come after us is expecting from us. Okay. So with that, let's get busy. Now I give honor to this video that was done by our brother Sarwan Seti on his platform in regards to his interpretation of the meaning of the 14th Amendment and how it applied in regards to uh, the contract that was created as a result of what happened based upon our servitude to the what we call the antebellum era. Okay, so he makes a good point about the express intent of the 14th Amendment, which a lot of you I don't think understand. All right, and even himself is a little lost on the meaning of the interpretation of the 14th Amendment, because black people are not protected based upon the color of skin under the 14th Amendment. 14th Amendment has to do with you being protected by a political society. Okay, a political society. If you're not protected by a political society, then you just are a resident that allows to be there, which is going to be subject to deportation as a result of the new agenda that has come forefront at this time. Okay, so it's very important that you pay attention to today's lesson. Okay, because without it, you would be lost. Let's get it. All right, become a member of the Sarbon Student Study YouTube page. Okay, become a member of a Sargon Suit and Steady YouTube page. Trump says that the 14th Amendment is exclusively to black slaves. Okay? To black slaves. So one thing they're calling them black, and another they're calling them slaves. So together they're black slaves. And we know black is a corruption of the word Negro. Okay? We know the word Negro comes from or originated in what we call Castile, which is Spain. Okay? Now my grandfather was recorded as a Negro, and he looks native to this land as a Native American, and he has the feature of a Spaniard. Okay, we know that Spain gave independence to Morocco through the Treaty of Cordoba. Okay, prior to that, all the inhabitants of Mexico, whether you want to talk about the Incas, the Aztecs, the Mayans, okay, all of these were just are those who were got their independence from Spain. Okay, we know through the Spanish conquest in 1491, they conquest the Incas, the Mayans, and the Aztecs, but they never conquered the Olmecs, which were the indigenous people at that particular time, and they were Negro. Okay, they had Negro features. So if they had Negro features and they were Negro, and the word Negro comes from Castile, which is on the Iberian Peninsula, then that means that wherever they went, their culture went with them. Okay, wherever they went, their culture went with them. Okay, so we must understand that to talk about it and not be about it is not what it's about. Okay, Brother Sarah Sunseti, thank you for the exclusive about, you need to enlighten yourself with the purpose of the 14th Amendment in regards to the 13th Amendment, which involves you. Okay? Which involves you. I'm pretty sure your name was not Sargon Suit. Okay? I know our ancestors at this time, around the 14th Amendment, didn't go by the names of Sargon Suit. Okay? So please, wake up, brother. You're very intelligent, very high, highly studious in whatever it is that you endeavor in. But I suggest that, you are broadening your horizon a little bit over here, uh, uh, a little bit more in the west versus the east. Okay, concern yourself a little bit more over here and what's going on. With that, let's get started.
History, culture, awareness, cultural awareness.
Just move up some.
To General Sarah Sunseti, DVD lectures, T-shirts, tank tops, hoodies, African and Kemetic jewelry, holistic tonics and remedies, home decor accessories for every room in the house. I got something for you, family. I know you're going to like it and love it. Get over there, check out.
He'll be a good deliverer of bad news. I like how he deliver news. You know what I'm saying? He's always happy with it.
Get something up here for you. Let me get something up here for you. I know you're going to like it.
Let me just find it.
What is it? Toothless ass. Always up there talking shit.
You got to watch his profanity. He do use a lot of profanity.
Yo ass. Here we go, family. It's uh we got Donald Trump. He's come out and along with a lot other people on top of Donald Trump to explain, the 14th Amendment, which was an amendment that was added by Congress to, to guard, the citizenship of blacks in this country after slavery. I believe it was the Dred Scott case, and guarantee that blacks in America, the children of those black, that their citizenship was guarded, by the Constitution, and verified by the Constitution. So that, but that amendment is, was created for us. You see now motherfuckers talking about, foundational black. What is that? Your ass about to find out what it is. You about to find out. You see? So now what do people say about that? I would like to know what people, would say about that. If, when it don't add you. See, they always act like we got to add a motherfucker. They always act like we got to add a motherfucker there. Why you separating? The goddamn Constitution has separated, and because you wasn't here at this time. You wasn't here. And so now that, Donald Trump and many others, they're coming out. And they, because what's happening is, people is illegally breaking into the United States. And this is right. We just can't make shit up for everybody just because, you think it's right. It ain't about what's right, it's what can be verified. You understand what I'm saying? Based on law. Based on the law. We have to see what can be verified based on the law. And when we look at that, it is those blacks, those slaves that right here, that, endured from the very beginning is who they created that the 14th Amendment for. And so you can't just break into the country and then have children and think you afforded some rights. You cannot be, what's the word I'm looking for? You cannot be awarded, for committing a criminal act. You didn't committed a criminal act, and we just have to understand that's just what it is. People thinking, just imagine if you just let any and everybody just come into the goddamn country and from all over the world. They say, well, what's the difference between us and the Mexicans and the Hispanics? Okay, let them come from you. Let them break in and shit and start, man, motherfuckers undermine the goddamn country like that.
Okay. So he mentioned too. He said what do you say? He said the Puerto Ricans and the Mexicans. We know the Puerto Ricans are the Spanish, and we know that the Mexicans are the Spanish. Okay? We are all the same people because Mexican got their independence from Spain by the Treaty of Cordoba, and we know that Puerto Rico it denotes to the island of the Spanish people. Okay? The island of the Spanish people, Espanol. You know what I'm saying? You can find that over on the Iberian Peninsula. Espanol. Okay? That's what Iberia was called before it became Al-Andalus. All right? So when you're talking about Negroes, Mexicans, Spanish, you're talking about the indigenous people here on this continent, as he said, who endured the conquest, the invasions, the servitude, all right? And as a result of that, we had to be returned back to our birthright here on this land. And that was not in Africa because Africa is here and here is Africa. Africa is on the Iberian continent because at that time it's not based upon the noun given to the name of the place. It's based upon the noun given to the name of the people because it's the people who named the place. And the people who named that place were Berbers. Okay? They were Berbers.
You know what I'm saying? If people knew that all they had to do was break in and goddamn had children and the children would be accepted as citizens, man, your motherfucking enemy would try to undermine you. You see?
That's what's going on.
That's like setting yourself up for your own demise. You see? What Jeff in there? What Jeff saying? What you saying, Jeff? What are you in there talking about? You ain't talking about shit, Jeff. Let me get your ass up here. Let's get Jeff up.
Let's excuse the French.
Let's see what
I
Jeff
know all of you are
about.
probably used to that type of
you
language.
Right. You jipping niggas out of real conversation. That's what it is, Jip, nigga.
It's a real conversation, but excuse the profanity.
What Jip got to say? Where you at, Jip? There you go. Here you go. Here you go. Let me put Jip up there. Let me get you up there, Jip. Now, what you talking about, Jip? Say, let's not play big, bro. Okay? Wait a minute. Wait a minute. Let me... Maybe you saying it in a way, let's not play, saying said he don't play. You know I don't play, but I don't know what you're saying. Explain that to me, Jeff. Is you saying said he get him? Is that what you're saying, Jeff? Then maybe that's what you're saying. You know what is that what you're saying, Jeff? Talk to me. I know damn well what a name like Jeff. You know, I always get on and then talk, you know. I've been got on good, brother. You know,
that's not his name.
Apologize and shit. Okay, see, I always do that. Y'all help me out. I'm sorry, Joe. I'm sorry.
Let me move it a little further.
All right, you know how I be. You know, I be looking. Being here going in. See, that's what happened when you ain't looking at the comments and you just happen to look in and you know you came in halfway in the goddamn conversation. They be talking to somebody else, defending my ass, and then I get to thinking they talking to me and shit. I say, oh no, okay, that's right. Wait, you know, well, let me had to do it to come over here and usurp you in your own land is to break in and have children, and then they can get citizenship. Get your ass out of here. Do the, you know, and you know, to all the family out there, listen, if you can come like everybody else and come through the legal way of gaining citizenship, that's the way that is done. Nobody affords us any type of your privileges as far as breaking laws in this motherfucker. You know, you get they'll throw a trumped up charge on our ass any given day for shit that we ain't even goddamn did. You know what I'm saying? So how in the fuck we gonna look at somebody else and say, oh, you done broke in this motherfucker and we gonna ride for you, and no, man, get the hell on. Ain't nobody riding for nobody, you know, breaking in illegal. You knew you was illegal. Illegal mean you did not go through the proper chain of command as far as, you know, how you enter in a nation. And all nations have rules and regulations. It's not one nation on the planet that does not have national rules and regulations on how, you know, outside.
Pay attention.
Enter into the goddamn nation. You got to have a passport, a visa. You got to come through come through customs and shit and all of that. You had to come through that. They got to check you and shit. You know, a lot of times they go through your shit, make sure you ain't got none of them chickens in your goddamn suitcase and shit. You know, and I'm not talking about the ones that lay no egg. And so, yeah, and so that's the proper way. Anytime I left and went some goddamn where, you know, you had to go through the goddamn customs. You feel what I'm saying? And they'll be looking at you, you know, and they might want to go through your shit or whatever it is, but that's the proper way of doing shit. You know, and y'all done came through the goddamn, and like I said, family, I went over a lot of these damn, these cities, and it's an actual fact. When you talking about Mexico, you talking about literally the most violent goddamn, literally the most violent goddamn motherfucker talking about America, man. Goddamn, Mexico is way more violent than America. I'm sick of motherfuckers. Yeah, it's some crazy shit that go on up in this motherfucker too.
It was just profanity, everyone.
But man, like we went over yesterday, and man, we went down the cities that's in goddamn. He said y'all paperwork better be good. You goddamn right. Goddamn it. You goddamn right. Y'all motherfuckers better be doing y'all family tree out there. You better be able to pull that motherfucker. Not only your goddamn driver's license and motherfucker pull out your lineage too. Your motherfuckers gonna need that. Motherfucker got his family tree. Look, officer. Yeah. Yeah. I'm down there now. I'm 20 generations over here. Yeah, niggas gonna get to explain it. Yeah, I was on the plan. Yeah, my great granddaddy was on plantation, so and so. Yeah, I've been here a long time. You know what I'm saying? Motherfuckers gonna get to pulling out. They're gonna get to pulling out family trees in this motherfucker to keep from getting, put up out this motherfucker. Yeah, that's just how it is. That's just how it is. But yeah, we got the video from Donald Trump. Let's go and play it. Yeah, motherfucker. When motherfuckers get pulled over, they gonna log in the goddamn what's that shit? Ancestry.com. Motherfuckers go log into Ancestry.com. Say, yeah, officer, look, I've been over this motherfucker for some generations and shit. You know what I'm saying? God damn. Here we go, family.
See this? This is a 400-ounce bar of solid gold. This could buy you a decent house, and so could this much cash. This
to get birthright citizenship or automatic citizenship for the children of illegal aliens. That's another way. It's automatic citizenship for children of illegal aliens. That's the other term that they use, which is actually more accurate, more understandable. And it's ridiculous. We're the only country that has it, and certainly the only country that has it to that extent. And it wasn't meant, if you look, it was really meant for children of slaves. This is when it happened. Children
you hear that?
Slaves. It's not meant for everyone to come into our country by airplane or charter.
Go back.
For everyone to come into our country by airplane or slaves. This is when it happened.
33.
This is meant, if you look, it was really meant for children of slaves. This is when it happened. Children. It was really meant for children of slaves. This is when it happened. Children of slaves. It was not meant for everyone to come into our country.
Now, so when we had this motherfucker.
So you see, the president said it was meant for the children of slaves. Okay? It was meant for the children of slaves. That we must comprehend. We know slavery started in North America in the 18th century. Okay? All right? As he spoke about, and as we constantly talk about, you must do your genealogy on your ancestry. Okay? You must have proof that you are in fact have a right to be on this land. And when I say right, I'm talking about just sanguineous, because just so is not going to do. He's telling you that now. Donald Trump is telling you just because you're born on the soil don't make you a citizen. Okay? He's starting with the criminals first, and then he's coming for the citizens. He's coming for those first who might give up a fuss, who might start a fuss. Okay? But the best believe it will be at your front door. Okay? It will be at your front door. All right. So, in lieu of that, let me just pull up my census, my ancestry.com to make sure that I'm in good standing. Right. That only makes sense. Right. I showed you this in my last lecture about Negroes, the Berbers. All right. This is my grandfather. Once again, show you again. This is my grandmother Ruth Jefferson, and this is my grandfather Lee Otis Jefferson. Okay, my grandmother Ruth Jefferson, my grandfather Lee Otis Jefferson. Here's a blow up of them. Truly Spanish features. Okay, not an Indian, but a Spanish Native American. Because the word Negro comes from Castile, and Castile is part of the Spanish Empire. It's the foundation of the Spanish Empire, going back to this founder, Pelagius of Austrias. Pelagius of Austrias. Okay, he was a Hispanic Visigoth, and we know that that goes back to the Byzantine Empire. Okay, dealing with the Berber tribes who were defending off the invasion and the conquest of what we call Arabs. All right, so that's my grandfather. A close up and a picture of my grandmother. Okay. Here's the 19th census of 1950. Once again, the census of 1950 in Mississippi. They spelled my grandfather's name several ways, like it is. It's pronounced several ways. It's spelled several ways. All right. They spell it Leadias. All right. Birthplace, Mississippi. Race, Negro. Okay. My grandmother's race, Negro. All right. Mississippi. All right. Whether you're talking about east of the Mississippi or west of the Mississippi, they were in fact Negro. And if you look at the word Negro, all right, if you look at the word Negro, spelled Negro, the Negro word is found in Castile. Okay, first found in Castile. Okay, so that means that my aunts, my forefathers, my ancestors, my grandfather, not just my grandfather, my great grandfather, and my great great grandfather were all Negroes. Okay, with English names. The name Jefferson. Okay, they got the last name Jefferson, but yet they have Spanish ties to Spain, which were unified with England by way of what we call marriage. Okay? Very important for you to understand this, to understand this lesson. Okay? The Negro was found in Castile. Okay? We know Castile was on the Iberian Peninsula. Okay? It went through many changes. Okay? It went by many names, but there's no disqualification, but they are in fact the same people. Okay? So since we've seen that they were in fact Negroes, which means that they are related to Spain, we know that Spain and England was unified, all right, in the Middle Ages, on not just here in North America, but as on the Iberian Peninsula. We know that through the Spanish colonization, through Roman Catholic Spaniards, they were invaded the territory here. Okay? Very important. Let's get another traits of my family. Right? Because they roll up on me, they're going to be in trouble. Right? Richard Jefferson and Emily Stovall, 1859 and 1861. Okay? This is my great great grandfather and my great great grandmother. Okay? Very, very important. Their children, Abby Jefferson, Beulah Jefferson, Minera Jefferson, Mary Ella Smith, Cleveland Jefferson, Early Jefferson, Settler Jefferson. All right? First generation, 1859, 1861, during the time of slavery. Okay? My great grandfather's name was William Tube Jefferson, born in 1875, and his wife was Ida Rideout, born in 1887. Okay? These are my great great grandfather and great great grandmother. My great great grandmother. My great 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 grandfather was Richard Jefferson. Okay? Very important. My great 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 grandmother was what's her name? Emily, what was her name? Emily Stovall. Emily Stovall. And both of them are names that originated in England. Okay. So William and Ida Rideout are my great great grandmother and grandfather. Their children, Paul Jefferson, my grandfather, Leotis Jefferson, they spell it Luotes Jefferson. His wife, Nina Ruth Jefferson. Okay? Ellis Neil Owens, Ruby Lee Jefferson, Paul Jefferson, Cornelia Mark Maggie, Roscoe Jefferson, Rosie Lee Teller, Verlene Jefferson. Okay? These are all my second generation family. Then you go down to my grandmother's children. They start with Jerry. And you come back here and pick up here. Yes, my forefathers were free men. Okay? Ruth Jefferson, my great grandmother, my grandmother, her brother, Jesse Jefferson, or son, pardon south. Her son, Jesse Jefferson. All right. My grandmother, Ruth Jefferson, her son, Jesse Jefferson. Willeen Jefferson, his sister. She was a Spanish Negro as well. All meaning black. The word Spanish for Berber is Berbera. Okay? Albert Lee Jefferson. That's her son. He's a Berber, Negro, black, Spanish. All right. So that is my family going all the way back to 1857. To 1857. Now, why is this important? First, once again, we got surnames. All right. Jefferson, okay, in the territory called Mississippi at the time where slavery is paramount, okay? Where slavery is paramount, okay? So let's start with slavery first and get a brief on that real quick again, because the name of the lecture is The American Revolution was to bar Entail and enslave the English heir. That was the whole purpose of the American Revolution, okay? All right. And when did the American Revolution start? 1776. Let's get it. With all that we just said and the status of my family, the legal institution of human chattel slavery comprised the enslavement primarily of African and African American was prevailing in the United States from its founding in 1776 until 1865, predominantly in the South. Slavery was established throughout the European colonization in America from 1526 during early colonial period, and it was practiced. It was practiced in what became British colonies, including the 13th colonies that formed the United States. And you read Dred Scott Cave, that case to tell you that the inheritance of slavery in the 13 colonies originated from Great Britain. It was transported from Great Britain to the 13 colonies. Okay, very, very important. This is all resulted in what we call the Reconstruction era. Okay, led up to what we call the Reconstruction era. All right, so it says that under the laws, an enslaved person was treated as property that could be bought, sold, or given away. Slavery lasted in about half of the United States until the abolition in 1865. You hear that? 1865. We all need to really realize what that means, okay? By the time of the American Revolutionary War, the status of enslaved people had been institutionalized as racial caste associated with African ancestry. During the immediately following the revolution, abolitionist laws were passed in most northern states, and the movement developed to abolish slavery. One of those abolishers or those who helped to assist in abolishing slavery was Roger Morris. He was a lawyer, okay? Roger Morris, contrast to another Robert Morris, who was the financier and who financed North America, who all participated in slavery. Okay, they all participated in slavery. Thomas Willing, and Roger Morris. They had a company back in the day which was based or rooted in slavery. Okay, but yet you got another Robert Morris is working as an abolitionist to do away with slavery. Okay, and they both have the same names. All right, very important. So by the time of the American Revolution War in 1775 to 1783, okay, the status of enslaved people had been institutionalized as a racial caste associated with African American. During the immediately following the revolution, abolitionist laws were passed in most northern states, and the movement developed to abolish slavery. The role of slavery under the United States Constitution, 1789, was the most contentious issue during its drafting. Okay, very, very important. That's all we need to know. So let's take it here. The end of Entail, information, institution, and slavery in the American Revolution. Once again, the end of Entail, information, institutions, and slavery in the American Revolutionary period. All right, everyone needs to understand it's published online by Cambridge University on the 5th of May, 2015 by Claire Priest. Okay, by Claire Priest, Cambridge University, y'all. For historians and property law scholars, The abolition of the fee-tail estates and land by many states during the American Revolutionary period served as a principal symbol of the power of Republican ideology during the founding era. Political leaders of the founding era deplored the system of hereditary privileges that defined the European aristocratic political order. Property served as the foundation of that order. Political, economic, and social privileges were associated with the ownership of landed estates. Property and inheritance laws enable families to retain land and therefore the privileges associated with land estates over the generations. Therefore, American historians celebrate the abolition of the fee-tail estate and primogeniture by some states as a practical and tangible achievement of the Republican Revolution. Did y'all hear that? I'll read it again if you did. For historians and property law scholars, the abolition of the fee-tail estates and land by many states during the American Revolutionary period served as a principal symbol of the power of the Republican ideology during the founding era. Political leaders of founding eras deplored the system of hereditary privileges that defined the European aristocratic political order. Property served as the foundation of that order. Political, economic, and social privileges were associated with the ownership of land and estates. Property inheritance laws enable families to retain land and therefore the privileges associated with land estates over the generation. Therefore, American historians celebrate the abolition of the fee-tail estate and primogeniture by some states as a practical and tangible achievement of the Republican Revolution. Okay, so the question is, how did they do this? How did they do this? Okay, let's see. Bob's Genealogy Filing Cabinet. It's articles from Southern colonial genealogies, all involving Entail. Tracing the ownership of land from one generation to another is a very useful tool of genealogy, which I've discussed elsewhere on the site. However, the usefulness of this tool depends on our ability to interpret the law relating to both land and succession. Entail, which touches on both ownership and succession, is unfamiliar to most genealogists, yet it's surprisingly how often we find instances of entail land, particularly in the colonial Virginia, and that's where it was abolished in Virginia by Thomas Jefferson legislative presentment to the House of Burgesses. Okay, that's how it ended. Definition: to overgeneralize a bit, land could be held in fee simple or fee tail. So there is a difference between the both, fee simple and fee tail. Fee simple was an unrestricted ownership. Fee simple was unrestricted ownership, pretty much the form in which we typically own land today. But fee tail was restricted form of ownership, and that it was essentially a life estate, and therefore the land could not be sold, mortgaged, or devised by will. You hear that? Sold, mortgaged, or devised by will. But that's how they do it now through fee simple. A person who held land in fee tail did not own it in the sense we think of ownership today, but rather was a sort of tenant with a lifetime right to the use of the land. After his death, land would pass to the specific successor, that the state of affairs would continue in theory for generations and generations. Land held in fee simple could be entail or converted into fee tail. Once entail, it remained to essentially forever. Clearly, that affects how we must interpret subsequent records for that land. Okay? Very, very important. So let's see the distinction between fee tail and entail. First of all, we need a little bit of history. Entailment of land had been prevalent in England for hundreds of years by the time of the colonies were founded. You hear that? By the time the colonies were founded, entailment of land had been prevalent in England for hundreds of years. And they talking about the colonies. Okay? So they must be talking about this is England. If they're talking about before the time of the colonies and by the time of the colonies. The concept of entail was codified in 1285 by the Donuts Conditionables on conditional gifts, one of Westminster statutes. In a country where land was scarce and societies highly stratified, the purpose served by entail was obvious. It had an effect of keeping large estates intact over long periods, thus providing a means for the testator to assure the wealth of the influence of future generations. And it did so by protecting the family line against a future generation who might dispose of any part of the land outside of the family. In America, where vast quantities of land were readily available, entail was far less important. You hear that? Why? Because it was really held entail. You didn't abolish it until you presented it to the House of Burgesses. Who presented it? Thomas Jefferson. Okay, Thomas Jefferson. Let's go back. Let's go down. Everyone on this on this lecture should pretty much know what entail is. Let's go to how common was entail. Let's start here. There's a difficult question to answer for the obvious reasons that land once entailed would be ignored in the will of subsequent generations. You hear that? Once entailed, no will, no deed, no any instrument whatsoever can disqualify you once it was left entailed. Therefore, we can simply count the proportions of wills that contain an entail provision. If we did, the percentage would be small, say 5% less than Virginia. Some authors have estimated that as much as 1/4 of all land in Virginia colony was entail. Although most authorities agree the estimate is much too high. The percentage of persons affecting what considerably lower for entail was a device used mainly by the aristocracy and others with large landholding. We just read that in the other article. However, it seems that unintentionally entailed land, mainly by poorly worded wills, was common enough in Virginia that the General Assembly felt it necessary in 1734 to provide a mechanism to dock entails of small inherited parcels. Once again, to dock entails of inherited parcels. The use of entail outside Virginia colony appears to have been quite low. Most northern colonies never recognized it at all. So we're talking about the Donuts conditions which prevented the entail to be substituted, which means alienated through what we call substitution, with the result of what we call common recovery, which results in what we call fee simple. This is the same as docketing, okay? Docketing the record, okay? So it says abolishing entail. Clearly, an heir might wish to sell the land or to divide it to someone of their own choosing, but could not do so without some means of docking or eliminating the entail and substituting a fee simple interest. I repeat, in order to be able to convey the land outside of entail, the only means to do that was by docketing or eliminating the entail and substituting a fee simple interest. This is called common recovery. This is called common recovery. Okay? The former mechanism required an act of legislature, a strategy available only by wealthy and persistent. The process itself was cumbersome, requiring approval from heirs and remainder and reversion, and usually that the entail land be replaced by entail lands of equal value. Of course, it is likely that poor recording keeping resulted in some small entail being ignored, at least in the frontier countries, with, of course, the collusion of the heir. Okay? This is very, very, very important, because docketing or eliminating the entail, substituting for fee simple, is a result of what we call common recovery, when they just said their Donuts Conditionables, which was passed in 1285 by Edward I, the king of the plantations crown, prevented it from being alienated through substitution, which is the conversion from entail to fee simple. Okay? Very, very important. That was abolished. All right? Stay with me, y'all. The Donuts Conditionables. Let's look at that for all those who don't know. The Donuts Conditionables, or the Estates of Entail Act of 1285, is a chapter of English statute of Westminster in 1285. It originated the law of entail, forbidding a landowner to sell his land except to his heir. You hear that, brothers and sisters? It's right here. Edward I, 1285. Okay, now just look at Queen Pretorius, another law passed by him in 1290. All has to do with New Jersey. Okay, all has to do with New Jersey. Queen Pretorius. I should be writing these words down. Queen of Pretorius is a statute passed by Parliament of England 1290 during the reign of Edward I that prevented tenants from alienating their land to the others by substitution, instead requiring all tenants who wish to alienate their land to do so by substitution. Okay? To do so by substitution. This statute, along with its companion statute Quaranto, also passed in 1290, was the law passed in regard to a statute of our Lord the King concerning the selling and the buying of land. Okay? To selling and buying of land. All right, so you got Queen Pretorius and De Donis Condition above, which were two laws passed by our ancestors, which were abolished by who? The state of New Jersey. Let's see. Estates entails abolished. Whenever any conveyance, will, or instrument in writing shall hereafter be made, whereby any grantee, not grantor, but any grantee or devisee or other person shall become seized in law or in equity of such estate in any real estate as under the statute of the 13th of Edward I, called the statutes of entail or de donis conditionibus, would have been held in the state and fee tail of any type of character. Now such conveyance, will, or instrument shall vest in the state and fee simple and such grantee devisee or person. That's called docketing or eliminating the entail. Once again, docketing and eliminating the entail. This was done by your founding fathers, and this was the cause of the revolution. Okay? This was the cause of the revolution. Okay? This involves Shelby's case. Okay? It involves Shelby's case, which is the next statute before. Right here. Rule in Shelby's case. Abolish. They abolished it. Okay? Let's read it before we examine it. How many ever heard anything like this? Have you, Brother McGarrell from the House of McGarrell? Have you ever heard anything like this? Please let me know. Whenever by conveyance, will, or other instrument in writing to take effect hereafter in a state of freehold, and any property is limited to a person, and the same instrument contains a limitation, either immediate or immediate, to his heirs or the heirs or of any of heirs of his body, or to the descendants or issue or any of them, in a manner or by any description such that, by the application of the rule of the common law, known as the rule in Shelley's case, the word heir and other words used in creating the interest after such estate of freehold will be held to be words of limitations, and not of the purchase, and such estates of freehold will be held to be enlarged by reason of the use thereof. Then, in any such case of the word heir or other words so used, shall hereafter be held to be the words of purchase, and not to be the words of limitation of such estate. Freehold should not be held to be enlarged by the use thereof, and to the end of that said rule of the common law, known as the rule of Shelley case, should not be applicable in any interest in property created by an instrument to take effect hereafter. Did you hear that? Thank you, Brother McGarrell. I know you heard that just from that statement. Okay, so if this is the case, we're reading that the statute of entail has been abolished. Okay, Shelby's case has been abolished, and Queen of Pretorius has been abolished. Let's see. All this is in the New Jersey Revised Statute 46:3-5. Queen of Pretorius. New Jersey Revised Statute 46:3-5, 2024. You can't dispute this evidence. This is proof, brothers and sisters, that they got to go home. From and after March 18th, 1795, any freeholder may give, sell, or alien the real estate whereof he is, or at any time to be seized in fee simple of any part thereof at his pleasure. Such donor, purchaser, or alienee shall have the same free of any tenure or service the donor, or seller, or aliener. So the aliener are the one who alienated, have conveyed it now and violated Queen and Praetorius, which said that land cannot be substituted. It had to be transferred based upon the original tenant who had it from the original grantor, which was the landlord, i.e., what we call, what was he called? Lord Mesne, okay? Under what we call capitite. You pay rent, okay, in cash. All right? Very, very, very important. So we see Queen Praetorius abolished. We see their donors condition of bus is abolished, as well as we see Shelby case abolished, all on account of common recovery. Once again, all on account of common recovery. All right, but common recovery was abolished. Okay, it's still being done now because Queen Praetorius and their donors condition bus law and Entail have been abolished as a result of common recovery, but yet the statute says common recovery has been abolished. You don't believe me? Let's look at the statute. So they, like the brother said, y'all criminals. Fines and common recoveries are abolished. Y'all see it. Okay? Fines and recoveries are abolished. Fines and recovery are abolished. From and after June 12, 1799, no fine or common recovery that has been or shall be entered, made, had, or suffered in any court of record of the state shall operate or to be construed to be a conveyance or assurance of any real estate. They're telling you, don't bank on it, or any way bar the issue of entail, meaning that they can't bar entail or the reversion or remainder of that lawful claims of entry, and any usage of custom to the contrary is anywise notwithstanding. Okay? Notwithstanding. So common recovery was abolished back in 1799. Okay? 1799. But yet they're still practicing common recovery because the only form of ownership in North America is what? Fee simple. And fee simple is a result of common recovery. How I know it? Let's look at it. Common recovery. You can't make this up. This is the spirit of my ancestors talking through me. Entails were originally designed to keep ownership of land within a family. Thanks to the effects of the statute de donis conditionibus, the intent of the entail could not be broken. I just showed you in the statute that New Jersey broke it. Okay? This meant that land and fee tail could not simply be sold, transferred, or mortgaged as whatever the current owner did with it. Ownership would automatically pass on the death to those specified by Entail. While Entail performed a valuable function in the 13th century, when the Donus Conditions was enacted, by the 15th century, the courts had extended their scope so that they were now perpetual. Social and economic conditions meant that the landowners were more concerned with being able to freely sell, convey, or mortgage their land. In the second half of the 15th century, common recovery was devised as a way to circumvent the donus conditional above. Everybody say who did it? New Jersey did it. All right? Why? You said it right there in the statute. You said it right there in the statute. You can't make this up. Common recovery was a legal proceeding in England. All right, now it's in North America based upon the statutes that enable lawyers to convert a entail estate, a former land ownership, also called fee tail, into absolute ownership fee simple. This was accomplished through the use of serious collusive legal proceedings, some part of which were fictional and others unenforceable, and therefore everyone said null and void. Null and void. How do we know they null and void? Let's look at the record. Let's look at the record. right here. In New Jersey, the kind of deeds that may be used to convey fee titles are what? Quick claim deeds. An executed quick claim deed transfer title to the real property without any warranty of the title from the grantor to the grantee, meaning that you pretty much on your own. Okay? Warranty deed is a warranty deed that purports to grant a deed that is supposed to be free from any defects. Okay? So it said warranty, the grantor warrants that the grantor holds a clear title to the real property from the beginning of the property origin. And that's based upon what we call a chronological trace of the chancery abstract. Okay? But yet, even though you got that chancery abstract, you still got to assure it by what? Title showing, just in case there is some type of defect in that deed, such as quick claim deeds, warranty deeds, as well as specialty warranty deed, which is a special warranty deed that grant the warrant to the grantee against claims to the title arising during the period of the grantor's ownership of real property. But no one's trying to quiet the title. No one's trying to quiet the title. Then you got bargain and sell deeds with covenants against grantors' acts. The bargain and sell deeds with covenants against grantor acts essentially to serve the same purpose as a special warranty deed. Purports to say that the title is clear, but there is a cloud on the title because there are encumbrances and there are easements on it. But in the more commonly used, it has covenants that the grantor has done not an act to encumber the property or to allow anyone to obtain legal rights which affect the property. That's under Title 46:4-4, the same statute governing property, which automatically tells you that 46:2-2, the property is supposed to be remaining free and common soakage under the king, body politic, person, corporate, etc. But they don't know that. But yet they're using the statute based upon how they do it now, which is what we call common recovery, which is based upon the simple conversion of an Entail estate, okay, which they call docketing the Entail, okay, docketing or eliminating the Entail. We must understand how important this is because they gave you the examples that set forth that the deed is actually not valid. How we know it? Let's look at it. Let's get some more proof. Allotio and freehold. Allotio and freehold. I talk all the time about allotio, so and we ain't gonna talk about that. We're gonna talk about the type of land ownership in America. Okay, the American-based system of land ownership today consists of three key requirements, which is what they do today. All right. The same requirements you find today. These three are the warranty deed of some other type, the purporting to convey ownership of land. Okay? First part of it. The warranty deed or any other type of deed purports to convey ownership of land. It doesn't prove you have ownership of land. Why? Because it's defective. is defective. There are encumbrances. There are liens on it. You don't own it by way of what we call quiet possession, meaning free and clear. Okay? Yeah, the cleared title is clear from anybody else having a right to use it, but yet you still subject to those encumbrances by the state. Okay? A de facto type of ownership. These three, so the three factors or the three key requirements in America-based system of land ownership is based upon some type of deed. This one talk about warranty deed, which purports to convey ownership of land. Then a title abstract to chronologically follow the development of these different types of deeds to that piece of property. The title insurance, then is title insurance to protect the ownership of that land. You hear that? So it's the purported deed, the chronological abstract, and then the actual title insurance just in case. Okay? Just in case. All right? So just not just warranty deeds. Not just warranty deeds, but any type of deed. Okay? Any type of deed. Let's see. The deeds include the ones as follows: warranty deed, quitclaim deed, sheriff deed, trustee deed, judicial deed, tax deed, rig, or any other instrument that purportedly conveys the title. All of these documents states that it conveys the ownership of the land, but in fact it does not. Okay? Each of these, however, is actually what? Color of title. For preparation and examination of abstract based upon title and real property, chapter 3, section 73, 1919. A color of title is that which is an appearance in appearance is a title, but which is really is not a title. Right versus Madison. In fact, any instrument may constitute a color of title when it purports to convey the title of the land, as well as the land itself, although it is void as a monument of a title. The Supreme Court of Missouri has stated that when we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea at least that some act has been previously done by which some title, good or bad, to the parcel of land of definite extent has been conveyed to him. Not saying you own it, but it has been conveyed to him. In other words, a color title is an appearance of a apparent title, an image of the true title, hence the phrase color of which, when coupled with the possession, purports to convey the ownership of the land to the purchaser. This, however, does not say that the color of title is the actual true title itself, nor does it say that the color of title itself actually conveys ownership. In fact, the claimant or holder of color of title is not even required to trace the title through the chain of down to his instrument. Okay? Very important that we understand that when you trace the title back based upon the chronological abstract, it must go back to the original owner, not the seller, not the lender, all right, but the actual owner. And for that, you need a letter pad, all right? Very, very, very important. Let's move forward. So any type of deed that you got is color title, right? It's color of title. Now, who was the recorder of deeds? Frederick Douglass was the recorder of deeds. Recorder of deeds or deed registry is a government often tasked with maintaining public records and documents, especially records relating to real estate ownership, that provides persons other than the owner of property with real rights over that property. You hear that? It records related to real estate ownership that provides persons other than the owner of property with real rights over that property. If y'all don't understand that, everyone must be asleep. Okay? You gotta be asleep. We just read that all things these found for the county record are color of title based upon the chronological abstract and the title insurance that you got based upon the deed or deed that purports to convey ownership. Because we know that it does not prove ownership, it only conveys ownership. All right. It only conveys or purports to a person other than the actual owner with the real rights over the property. So once again, I repeat, Recorder of Deeds or Deed Registry is a government office tasked with maintaining public records of documents, especially records relating to real estate ownership, that provides persons other than the owner of a property with real rights over that property. That's called an easement. An easement is a non-possessory use in property without actually possessing it. Okay? We must understand that. United States. Right here. Other United States maintain their deeds under the common law system of record title. That goes back to Turin's law. Turin's title. Typically, they are filed with the chronological order with a grantor, grantee index. Okay? None of those who sell who convey the land based upon seller or buyer are actually the grantor, all right? Because they don't even own the property, okay? They don't even own the property. In the United States, most recorded of deeds are elected officials who serve the area of a county or equivalent jurisdiction, okay? Equivalent jurisdiction. Let's move forward. Let's go here. Croxwall versus Shepard. Croxwall versus Shepard, okay? Before we read the case law from the United States Supreme Court in 1833. In 1833, Croxwall versus Shepard. That's the case. But before we read that, we're going to read a little bit about the person who built it. This is Robert Morris. Okay? Robert Morris. You got two Robert Morrises. Here's one Robert Morris. Robert Morris, 1823 to 1882, was one of the first African-American attorneys in the United States and was called the first really successful colored lawyer in America. You hear that? Robert Morris. At the time of slavery, he defended slaves. All right? He defended slaves. Robert Morris. Now we have this Robert Morris as well. Robert Morris. So you got one Robert Morris that's a abolitionist, all right, which apparently means he's a free man, okay? And then you got another Robert Morris who's a financer as well as a slave master. Robert Morris was an Englishman, which is a lie. He's doing everything in the name of the English, but what he was no Englishman. Was a foreigner, and I'm gonna correct it. Robert Morris was a foreigner born in America, merchant, investor, and a politician who was one of the founding fathers of the United States. He served as a member of the Pennsylvania Legislature, the Second Continental Congress, and the United States Senate, and was one of the only two people who signed the Declaration of Independence, the Articles of Confederation, and the United States Constitution, the other being Roger Sherman. From the 1781 to 1784, he served as the Superintendent of Finance of the United States, becoming known as the Finance financier of the Revolution, along with Alexander Hamilton, Albert Gallatin, and he was widely regarded as one of the founders of the financial system of the United States, being the founder of Bank of America. You hear that? Bank of America. Right here. Morris also reformed government contracting, establishing the Bank of America, the first congressionally chartered national bank to operate in the United States. You hear that? This Robert Morris. All right? This is the positive side they focus on, but not the negative side. We only get the negative side from Thomas Willing, his counterpart, or his co-partner. Thomas Willing. Thomas Willing was an American merchant, politician, and slave trader who served as mayor of Philadelphia and was a delegate for Pennsylvania to the Continental Congress. He also served as the first president of the Bank of North America and the first bank of the United States. During the tenure there, he became the richest man in America. I wonder why. I wonder why. Let's see a little bit more about his life. Whoa. Thomas Williams was born in Philadelphia, the son of Charles Williams, and was twice served as mayor of Philadelphia. And Anne Shippen, granddaughter of Edward Shippen, was one of the second mayor of Philadelphia. His brother, James Willing, was a Philadelphia merchant who later served as a representative of the Continental Congress and led a 1778 military expedition to raid the holdings of the British loyalists and where everyone said, Natchez, Mississippi. He served under President George Washington, John Adams, and Thomas Jefferson. All right. Okay. So he was under the authority of George Washington, John Adams, and Thomas Jefferson. Okay. We must understand that. All right. And he had an expedition to Natchez, Mississippi, which was the first place based upon the antebellum where the enslavement of the blacks really took place, going back to what we call Natchez, Mississippi. What was it called? I did it. What was it called? What was that video called? The Devil's Punch Bowl. Once again, Devil's Punch Bowl was in where? Natchez, Mississippi. Very, very, very important that we understand that. There's no getting around this truth. Not while I'm at the steer of this ship. Career. Listen. In 1749, after studying in England, he returned to Philadelphia where he engaged in mercantile pursuits in partnership with Robert Morris. They established the firm Willing Morris Company in 1757, which exported flour, lumber, and tobacco to Europe while importing sugar, rum, molasses, and slaves from the West Indies and Africa. Their partnership continued until 1793. Williams himself owned slaves, 3 in 1779, but none in 1782, which is a lie. We know they own more. So there you go. There you have it. Okay? Robert Morris and Thomas Willing were enslavers, okay? Under the authority of the president, George Washington, John Adams, and who else that was? And Thomas Jefferson, okay? The one who abolished entail estates, the one who abolished the donuts conditionalibus, the one who abolished queen imperatoris, the one who used a practice called common recovery, which is all right there in the modern day New Jersey revised statute, okay? All this was committed by Roger, Thomas, and Thomas Willing under the guidance of your founding fathers, which was the whole basis for the American Revolution, okay? We must understand that. Y'all still don't believe me? Let's go to proof. Let's go here. Update. Robert Morris. Founders of slavery. Founders of slavery. You can't make this up. Remember to send your gift donations to $ Clifford Jefferson Elbow or Third to English Church of England. Your patronage is well received. April 19th, 2015. Update. Robert Morris. Okay. This is a lithograph created by William L. Britton in Philadelphia, Pennsylvania in 1830. This image shows the home that Robert Morris and his family lived in before he gave it to George Washington when he became president. Robert Morris and George Washington both owned slaves, which were kept here. So Thomas Welland, George Washington, and Robert Morris owned slaves. Y'all better listen to me. All your presidents owned slaves. Hell, Donald Trump owned slaves. All the citizens of the United States are slaves of Donald Trump. Okay? Are slaves of Donald Trump. And now he's telling you, y'all slaves is free. Y'all slaves is free now. Y'all can go home now. That's basically what he's saying. Y'all can go home now. Why? Because the heirs have returned. All right? That's what Sarmasoon said he was saying. Robert Morris was the founding father who signed the Declaration of Independence. He was born January 31st, 1734 in Liverpool, where slavery took place. All right, the Atlantic slave trade. In Liverpool, England, but spent most of his life in Philadelphia, Pennsylvania. He was the nation's founding capitalist and the financier of its revolution. All right, the financier of the revolution. This is on, like I said, foundation of founders of slavery, contradictions of liberty, creations by students from Marlborough University, history 399, slavery and abolition in the Atlantic world. Okay, Robert Morris, Thomas Jefferson, Thomas Welland, Abraham Lincoln, John Adams, and George Washington. All of them were slave traders, slave holders. Okay, and they're still enslaving the identity of the people. Thank you, thank you, thank you, thank you. I appreciate it. All right. Okay, let's read a little bit more about this Robert Morrison. Okay. The apple don't fall far from the tree, brothers and sisters. The apple don't fall far from the tree. Okay. And we're talking about the change from Entail estate to fee simple, and fee simple is based upon the three requirements: a deed which purports to convey property, the chronological abstract title, whether at the county clerk or the court of record, and then the title insurance to assure that which is defective on the county record or the court of chancery in lieu of the warranty deed. Okay, which all established based upon abolishing quintuplitors and their donors conditional books, and the matter was brought up based upon Robert Morrison bringing the claim on behalf of property that he built on behalf of his daughter, Croxwell Mansions. Croxwell. It's called Croxwell Mansion in Belvedere, New Jersey, 07823 in the United States. Okay, this is the property in question, and guess what? It's still on the market. It's still being conveyed. All right, being sold off. It ain't being passed down based upon Entail. It's being sold based upon fee simple. All right, based upon some security agreement that was defaulted based upon the debtor. Okay, creditor, debtor. Lender, borrower, lender, receiver. Okay, you must understand the tricks of the trade. Let's see. Historian information on Croxwell Mansion. Croxwell Mansion. Historically known as Croxwell Mansion, this Gregorian-style home was built in 1780 by Robert Morris, who owned the largest tract of land south of the Peguis River that was originally surveyed by William Penn. Now, William Penn took his property by the twig and turf ceremony due lottery of season, but with a deed, not by law, but with a deed, and we just disqualify all deeds that you can even come up with. Okay, so even his process was void. All right, color a title. All right. Not applicable, not enforceable. So William Penn set the trend for Robert Morrison. It said Morris built the house for his daughter Mary Coxwell. The original front facade faces the Delaware River. Okay, move a little further. We already know about his life. I don't want to go into that. Let's read here. Right here. Following the war, Morris expanded his fortune through investments and unsettled lands in the nation. Through the devious design of his political enemies and some bad ventures by the late 1790s, his credit had collapsed, and Morris was sent to the debtors' prison in 1798, and that's where everybody else is going. After release in 1801. He spent the last 5 years of his life in near poverty, sustained only by a stipend from fellow statesmen in the articles and Constitution signer Gouverneur Morris. Okay? Y'all better listen to me. The plot thickens. Before going into depth in 1793, Robert Morris deeded the house in all 1614 acres to his daughter Mary Coxwell and her heirs forever. A New Jersey Legislative Act in 1818 reversed the forever part. Did you hear that? A New Jersey Legislative Act in 1818 reversed the forever part, converting it to fee simple in 1825. All of Mary's children had their mortgages paid by Garrett D. Wall, converting ownership to him. In 1826, there were only 7 residents such as south of the Pequest River. Wall donated the plots of the land to Warren County for the county seat. He sold the rest of the lots and thereby propelling Belvedere to go south of the Pequest. By 1841, there were 662 dwellers and nearly 1,000 people in the town. And in 1870, the census reflected 1,882 people. The completion of the Belvedere-Delaware Railroad was added boom. Thus, through the unfortunate collapse of Robert Morris' fortune, was a Victorian town established in rural New Jersey. Boom. Boom. You can't get no better. It's fee simple. That means it's a deed, which means the color deed filed on the county record. How? Let's just check the record if that's the case. Hey, it was up for sale. It was sold in 2003. Same house. Sold in 2003. For how much? Let's see how much. Almost $500,000. Okay? 0.3 acre lot. Uh, 4,140 square feet, 2.5 baths and 6 beds. Single family house built in 1780. You hear that? Last sold for $350,000 in the year 2023. Okay? And whoever got it now don't own it, because whatever deed they got is what? Defective, because it's color of title. Because why? You can't prove you own it, because the chain of title don't go back that far. Okay? That's why you got title insurance. All right? We must understand not just this house, but every house on the block and every house in the community, every house in the state, every house in the United States is done the same exact way. Okay? The same exact way. Thank you for the compliment. I have to part of my doing so. All right. Now we see everything out there in open front. Okay. Roger Morris went broke. Okay. Everyone who's buying property off credit, because money, fiat money, paper money, what they call wildcat banking, is fraudulent mortgages. Okay. We must understand that. How we know it? Let's look at the case law to prove it. Let's go back to the case. Coxwell versus Cherie, because that's his daughter. Okay? That's his daughter. Who else gonna drop like this? This was the United States Supreme Court say, and then it's in the District Court of New Jersey. Okay? District Court of New Jersey. Ain't in Alabama, ain't in Georgia, ain't in Virginia. This is in the District Court of New Jersey. Okay, why? Because guess what? New Jersey was the crown. Okay, New Jersey was the crown. In lieu of the crown's claim, any other claim is defective, and I represent the crown. Let's get it. Let's get it. Icing on the cake. Icing on the cake. I didn't even have to go into the material I talked about yesterday. All right. This is icing on the cake. All right. We know we are heirs to the land because Donald Trump said it. Donald Trump said the 14th Amendment was exclusively for those who were enslaved, and those who were enslaved, now called black people, were the niggas. They were the Negro, and Negro comes from Castile, and Castile was a empire. It was an empire of niggas. Okay, what you want to call them? Negro, niggas, Negra, whatever. The word, those niggas was called Berbers. All right, the word Berber in Spanish is Berber, and the English word is Berber. Okay, we must understand that you're not gonna get no deeper than this. They're gonna have a time with us. United States Supreme Court, error to the Circuit Court of the United States of the District Court of New Jersey. The person who brought the complaint was in error. In error. Okay? All concerning Shelley's case. Okay? All involving the donors conditional above the statute of Entail. As a result of the common recovery practice that they asked is practicing, which is nothing more than changing entail into fee simple, is called docketing to entail or feather the estate. Once again, it's called docketing or unfeathering the estate. That's what it's called. Docketing or unfeathering the estate. All right? So let's look at the new revised statute again. All right? It's in 2024. All right? And we're taking this back to the time of Roger Sherman. Okay? Pardon, sir, Roger Morris. Why didn't Roger Morris, the attorney, know this? Okay? It wasn't their time. New Jersey Revised Statute 46:14. Who can dispute this? Watch what they say about your estate. All right? That New Jersey took away from me. Watch what they say. Rules in Shelley's case abolished. Right there. The next statute, estates entails are abolished from Edward the First. Okay? Edward the First. And just in case y'all think that statutes entail is not the same as they don't condition the bus, let's just look it up. Just to make sure. Statute of entail. It's a legal term. Common law term. see. Well, come up to they don't condition the bus. So that's statutes of entail. Right? They don't condone condition the bus. All right, so I ain't gotta look it up. Let's go back to the case law. Foxwell versus Sharif, 1866, era of the Circuit Court of the United States for the District Court of New Jersey. As a general thing, any legal conveyance will have the same effect upon an equitable estate that it would have upon the like estate at law. And whatever is true at law of the latter is true in equity of the former. The rule in Shelley's case applies alike to equitable and to legal estates. And an equitable estate tail may be barred in the same manner as an estate tail at law. You hear that? But they abolished it, brothers and sisters. They abolished it. Come on now. This is crazy. How would they abolish an estate that was not supposed to be abolished? Somebody explain that to me. Okay? And the ones who did it were your founding fathers: Robert Morris, Thomas Jefferson, John Adams, George Washington, Thomas Willing. Okay? They did it. And common recovery was a scheme created by lawyers. So how come this Robert Morris didn't know this? Okay? How come Frederick Douglass didn't know this? He was the recorder of deeds. He was the recorder of deeds. How come he didn't know this? It wasn't their time. But now we know it. Okay? Now we know it. Robert Morris, a lawyer, at the time of slavery, when our land would be taken from us, all right, when our land was being stolen from us and being used for feudal tenure, okay, and we became the peasants and the serfs, okay, and they're living up to chain of title, okay, all right, holding us as vassals. That's not going to be anymore, okay? That stops this year. Let's see. To understand that equitable lives in equitable estates as well as in states, equitable states, entail as well as states entail at law, okay? Because we know law and equity are two different things, okay? It says too, a use of limited upon a use is not affected by statute of uses. This is called the laws of usury, okay? The statutes of usury. The statute executes but the first use. Listen, y'all. The statute, it executes it, means put things in motion. This is called operation of law. The same statutes you read in the statutes, that executes, put things in motion by operation of law, excluding a deed. Okay? That has nothing to do with operation of law. It's bound by some law, but not operation of law. It's based upon how much money you got in your pocket. Okay? That's how they rule with that. A use limited upon the use is not affected by the statute of uses. The statute executes but the first use, okay? And the conveyance by deed, i.e. the three requirements, warranty deed, tax deed, sheriff deed, mortgage deed, whatever it is, a bargain and sell, and the whole force of the statute is exhausted in transferring the legal title in fee simple to the bargainee, okay? Meaning that once the conveyance is done, the statute is executed, the conveyance is exhausted, okay? But yet, all that property that was held based upon the conveyance, called an easement, and use in property without active possession, is based upon the second use, which remains as a trust. You hear that? It remains as a trust, okay? So that means that everybody's been using our trust, okay? Based upon these de facto color of title deeds that were filed in the county conveying property other than the owner. That's what it said when we read it, right? That's what it said. So we see that Robert Morris and everything he accumulated was diminished in 1818 by an act of the legislature of New Jersey, okay? Not an executive decision, but an act of the legislature in 1818, okay? By which an estate meant to be settled is apparently some sort of tale, but over the deed settling, which was executed in 1793, doubts and difficulties of law hung, making the right of the several parties uncertain. the object of which private act was to dock the entail and unfeather the estate. Once again, to dock the entail and unfeather the estate and divide it equally between children and fee was held to be the proper exercise of the legislative power to effect an insurance of title through a private statute and ballot all parties in the interest in essay at that time. You see that when it said that it went changed from forever to fee simple. Okay, it went forever to fee simple. An essay having been before the legislator, having either asking for the act of consented that it should pass, and there being no ground for imputation on any of them of fraud, indiscretion, or concealment. The petition, moreover, had been made by disinterested commissioners, having been equally and fair, and all parties in essay and interest having confirmed it by the conveyance and release mutually made. So they all agreed to have the matter decided in the court as a result of it being divvied out based upon some type of conveyance based upon the will. All right, but it was not entail; it was fee simple because it said it went from forever, which are it's called a hebenden, which was a clause and a type of trust. Okay, that denotes to all parties involved in that trust. Okay, this particular issue was not the case. How we know that? Let's go to page 13. And we know the word docking and unfetter means to remove the entail. Okay, to remove the entail. Okay, right here. With private acts was to dock the entail and unfeather the estate. Once again, to dock the entail and unfeather the estate. To release the estate. Not to you, but to them. How we know it? Let's go back here to entail. How did they abolish the entail? I'm not saying it. They saying it. And they did it through an act of legislator. Okay? In 1776. And the act of legislator in 1818 dissolved it. Okay? It was created in 1776. Pardon, so. United States abolished entail in 1776. And then which was the process in which they were using, all right, to convey property fee simple based upon entail, but the court turned it and changed it for forever to what we call fee simple. And we know fee simple was the practice in which all land is conveyed nowadays, and we call this common recovery. Once again, we call this common recovery. Now check this out. Abolishing entail. Clearly, where is it at? Clearly, an heir might wish to sell the land or to advise it to someone of their own choosing, but could not do so without some means of docketing or eliminating the entails and substituting for fee simple interest. This is called docketing and feathering the estate. Once again, docking and feathering the estate, which means to change it from entail to fee simple. England has a complication process to dock entail as early as 1472, and that's the Talcum case, known as common recovery, that involves some complication fictions. As far as I can tell, this device was not used or very rare, was not used or very rarely so in the American colonies. Okay, so if it was rare or very rarely used in the American colonies, what the hell is going on then? Okay, what the hell is going on? Because common recovery was sanctioned in 1472 by the Talcum case right here. Common recovery was a legal proceeding and process in England that enabled lawyers to convert an entail estate of land ownership, also called fee tail, into absolute fee simple. Isn't that what the court did to Roger Morris estate? Isn't that what they did? Come on, this is thanks to their donors conditional buzz. Thank our ancestors for that. They did that. Right there. You can't substitute or change entail state into fee simple. It's forbidden. How we know it? Let's go back to the case. Page 13 in closing. Is it good, Brother McGarrell and Brother Dubbing? Are you enjoying this lesson? Let me know in the chat. They're going to repeat the same verbiage. Now we know Shelley's case and Entail were abolished according to the statute. All right. Shelley's case would not apply in that view of the subject. Thomas and not his mother was the donee Entail. Thank you, brother. Appreciate it. A use limited upon a use. Yes, sir, brother. Well said. Brother Dumming said, so they've been cashing out and having things by using private trust and statuses. Exactly. Okay? You are a dead, mortgage means dead pledge. So they already know it's going to be foreclosed on. You can never own it. Okay? You're going to wind up paying some tax you're going to renege on because taxes constantly going up. Taxes going up, mortgage is going up, incumbents is going up, i.e. phone bill, light bill, water bill. Come on, man, please. It's just a matter of time. All right? Let's check it out. A use limited upon the use is not executed or affected by the statute of uses. This is pretty much what we read in the narrative and the syllabus when we first opened up the case. Same thing. This is the use, but they're going to go in depth. They say the best for last. The use limited upon the use is not executed or affected by the statute of uses. The statute executes only the first use. In the case of a deed of bargain and sale, meaning that the statute executes only the first use. In the case of the deed or bargain sale deed or warranty sale, warranty deed or a tax deed or a sheriff deed or a mortgage deed, the whole force of the statute is exhausted once the conveyance has been done. Conveying through that legal instrument or that legal title, which is nothing but a purport of ownership, because why? It's fee simple. But the second remains, why? A part of the trust, because it only can be enforced in equity according to equitable laws. Okay? According to equitable laws. But without pursuing the subject, let it be conceded the purpose of this case, that Thomas Croxwell was the donor, first tenant Entail, and that he took a legal estate as contended by the counsel for the plaintiff in error. Let's see. Taking this view of the subject, the first inquiry to which we should direct our attention is as to the effect of the act of legislature of the 14th of February, 1818, and of the proceedings which were had under it. All the parties in interest then in essay were before the legislator and asked for the act or considered that it should be passed. Let's go back to the proof involving the property. Let's go back to the proof involving the property. All right. Can't lie. Belvedere, New Jersey. Following the war, Morris expanded his fortune through investments in unsettled land and the nation. Through the devious designs of his political enemies and some bad ventures, by the late 1790s, his credit was shot, and he collapsed. And Morris was sent to the debtors' prison in 1798. After release, that's called the Exchequer Chamber. After relief in 1801, he spent the last 5 years of his life in near poverty, sustained only by a stipend from fellow statesmen and articles and Constitution signer Governor Morris. He was corrupt too, I bet you. Okay? Before going into debt in 1793, Robert Morris deeded the house in all 1614 acres to his daughter, Mary Coxwell, and her heirs forever. A New Jersey Legislative Act in 1818 reversed that forever part, converted it to fee simple. You hear that? Converted it to fee simple, and by 1852, all married children had their mortgage paid by Garrett D. Wall and converted the ownership to him. Okay? We must understand that. So let's go back to the case law in closing. Back then, there is no grounds for the imputation upon either of them of any fraud, indirection, or concealment. Why? Because everything they were doing back then was based off fraud, indirection, and concealment. So they ain't gonna call anybody on it. It is not denied that the act was deliberately passed, nor that the partitions made under it by the commissioners was fair and equal. All the parties testified their approbation and confirmed it by their subsequent conveyances. The legal doubt and difficulties which hung over the deed, the uncertainty of rights of the several parties, the learned and elaborate argument and conflicting views of the council, and our differences of opinion in this legal evidence, the wisdom of the equity of the act. Opinion is this litigation invents the wisdom and the equity of the act. It is clear by implication as it could be made by expression that the object of the legislature was to dock the entail and unfeather the estate, meaning to uh, to uh, change it from entail to fee simple. Okay, that was the purpose of the legislature, which they all agreed to. That's why they all got a part of it. All right, and was what it implied is an effectual as what is expressed. If it were possible for the parties and the legislature to accomplish this object, it was thus done. Okay? It was just thus done. Had they the power, though, when the deed was executed, listen, y'all, when that deed was executed, when that deed was executed, when that deed was executed, the statute of the Adonis was enforced. Everyone said, in New Jersey. So how did it get abolished? Everyone hold that thought. Sorry about that. Sorry about that. So I said, had they the power to dock the Entail estate, to dock and feather the estate? Did they have the power to do so? All right. Because we know that Entail estate was not supposed to be docketed. Okay. Due the process of County Curry, we changed it from Entail to fee simple. Had they the power, it stayed right here in this case from 1866 when the deed was executed. That deed, the statute de donis, was enforced in New Jersey, but modified by the act of her legislature of the 25th of August 1784 and of the 3rd of March 1786. Fines and recoveries, as known in English law, were then part of her judicial system. Okay? They were abolished by the Act June 12, 1799. We know that because when we go back to the statute, common recovery was abolished. Okay? It was abolished, and that means that that act back in 1818 was not supposed to be enacted because it allowed for the docking of Entail when Entail was not supposed to be allowed to be docked. Okay? It was not supposed to be docketed. When we go back to the statute, it says right here. From after June 12, 1799, no fine or common recovery that has been or should be entered, made, or suffered in any court of record of the state should operate, be construed to be a conveyance of assurance of real estate, or anyway bar a issue in Entail. Okay? Bar a issue in Entail. An issue was a part of the statute when they created the statute to bar the Entail. Okay? Did they have the power to do so? No. They didn't have the power to do so. But yet, why? Because their donis conditionis was enforced at that particular time. But yet, they did what? They abolished it under the statute. You've seen it. I'm not going to go back to it because you've seen it. Okay. So it said, once again, what is implied is an effectual as what is expressed. If it were possible for the parties in the legislature to accomplish this object, it was done, and which was what? To convert Entail into what we call fee simple by docking and unfeathering the Entail. Okay? We must that. That's how New Jersey stole it. Had they the power to do that though? Because when the deed was executed, as well as the legislature passed, the statute de donis was already enforced in New Jersey and modified as well. And fines and recoveries was known in English law, were then part of the judicial system, but they were abolished, okay, by the Act of 13th of June 1799. It was declared that no British statute should therefore have any force within the state, okay, in regards to what we call common recovery, because common recovery said that you can bar Entail, okay, and in the court of New Jersey. That's what it said. Estates entailed under the statute de donis were before the passing of the legislature known as common law as conditional fees. Like estates entailed, they were limited to particular heirs to the exclusion of others. The condition was that if the donee died without leaving such heirs as was specified, the estate should revert back to the grantor, not the seller, not the buyer, not the creditor, all right, not the adverse possessor, but the grantor. According to the common law, upon the birth of such issue, the state became absolute for three purposes. One, the donee could alienate and thus bar his own issue and the reversioner. Two, he could forfeit the estate in fee simple, but it was a treasonous act before he could only forfeit his life estate. So if you're forfeiting the estates that belongs to heirs, that's an act of treason. That's an act of treason. Okay? Very, very, very important. All right? Is this state of law, it became useful for the donee as soon as the condition was fulfilled by birth of issue to alien and afterward to repurchase the land. This gave him a fee simple absolute for all purposes. The heir was thus completely empowered of the ancestors, and the bounty of the donor was liable to be defeated by birth of the issue for whom it was his object to provide, okay? To provide, to prevent such results and to enable the great families to transmit in a perpetuity the possession of their estate to their posterity. The statute de donors of Edward I, known as Statute Westminster II, was passed as provided by the statute. Okay, and we see in the statute it was abolished. Let's go to it in closing. Right here. Whenever conveying this will or instrument in writing shall hereafter be made whereby and granted divides a person should be become seized in law and equity of such estate in any real estate or as under the statute or Edward I, called the statute of entail, would have been held in the state in fee tail of any type of character, such conveyance will or instrument shall be now invested in fee simple. Okay? So this is what Robert Morrison did. This is what Thomas Willing did. Okay? This is what George Washington did. This is what John Adams did. This is what Abraham Lincoln did. This is what all of them did, okay? We must understand that because that was the purpose of the recorders of deeds, okay? That was the purpose of the recorders of deeds, which was record property that did not belong to them, okay? To record property that did not belong to them. And I read it in closing. The recorder of deeds or deeds registry is a government office tasked with maintaining public records and documents, especially recording related to real estate ownership that provides persons other than the owner of the property with rights over that property. So with that being said, my brothers and sisters, with that being said, understand that your birthright, all right, based upon your citizenship, is rooted in your subjectivity to the Kingdom of England under the authority of the Crown. And if that is your obligation and you live up to it, you have an estate in Entail waiting for you. Why? Because being that you were assumed to be dead, it's ceded to the Crown, okay? And as a result of who I am, as a result of my obligation and my capacity as Prince Patriarch of the English nation, I'm obligated to protect you and the property as well. Okay? And I'll close out on Crown Land. I'll close out on Crown Land. CROWNLAND. Crown Land. Brother Dubbing says, man, it's good that our ancestors set up the law like they did to make it, to me, it's like fitness, what is it? Like finest of the finesses of the finesses, setters, what is that? Finesses, it's like finesters and finesser. Settler and immigrant. I like that. I like that, Brother Dubbin. Crown Land. Crown Land. It's when Jesus said, everything that was for you, I got it with me. It's with me. Okay? It's with me. Jesus coming in the cloud, remove that cloudy title on this vast estate. Not in the air, but the vast estate here on land. Okay? That's the cloud he came to remove. Okay? That's showing a quiet title. To quiet the title. Okay? To quiet the title. All right? So Crown Land, also known as Royal Domain, is a territory area belonging to the monarch who personifies, who incorporates, who incarnates the crown. It is equivalent of a entail, you hear that, estate, and passes with the monarchy, being acceptable from it. So when the monarch left, all the authority governing the land left with it, and everybody else claimed that it was abandoned. No, once the king come back, it now reverts back by way of reversion from to the long lost king. Okay. Today in Commonwealth Williams, Crown land is considered public land and is apart from the monarch's private estate. Okay. So with that being said, we have to give honor to our ancestors. We have to give honor to our ancestors, and I'm giving honor to mine. Bruce Jefferson and Leotis Jefferson. All right, descendants of Richard Tube Jefferson, 1857. Okay, so with that, let me stop. I don't know who all going to watch this lesson, but just look at all the images of all the people behind us that are dependent on us. Okay. All right. Look at all the people who are dependent on us to choose them. Okay. All right. This is what you're actually looking at. This is actually what you're looking at. I'll close that on this. Body of politics. This is what you're looking at. Body of politics. If you're looking at the picture behind me, I'm going to show you what's missing from that picture. Me. I'm what's missing from this picture behind you. Right? Let me show you. Look at the picture. Okay. Body of politics. Right? What you see on this body of politics, on the body, on the figure in the picture, represents the people looking at the Savior, okay, or God, or the ruler, or the king, whatever term you choose to put in there. It's the people looking for insight, looking for protection, looking for guidance, okay? Very important. What you see here, you see in back of me, okay? But the people are looking at a king. The people behind me are not looking at anybody. So they're still got their hands up praying for somebody to come, okay? For somebody to come and restore them back on the land. Because without that person ruling, they don't have a place on the land. And only for that to come, you must understand body of politics, okay? See, did it show you? Sure, I guess it didn't share. With me. so you can see. Look at the picture. Blow it up again. If you can look on the chest, the body, okay? Not a separate body of politics, but a fusion of power. Legislative, executive, judicial, okay? A fusion of power. As you can see, the people look to the king, the Lord, the ruler, all right? The head of state, whatever it is, the people look to. What people don't? Because if you can look behind me, our people have been looking for somebody, but nobody's have yet to fit that description to get the job done. Everybody's claiming that they fit the description, but no one has yet done the job. Okay? Very important. So in lieu of our people, the nigger, the Negro, the Spanish kings, the English kings, the French kings were all family because they were the families of the Berbers. Okay? We must understand that in order for you to be protected, you must return to your body of politics. Your body of politics. And a body of politics is a polity such as a city, rim, or state, considered metaphorically as a physical body. Okay? A physical body. Historically, the sovereign is typically portrayed as a body's head, and the analogy may also extend to other anatomical parts as the political reading of the belly and its members. The images originate in ancient Greek philosophy beginning in 6th century BC and was later extended in Roman philosophy. So this is folklore, myths, Renaissance interpretations versus our understanding of the body of politics and how we construe the body of politics being affiliated with it. Following the high and late medieval revival of the Byzantine, hear that? Byzantine, corpus juris civilis in Latin Europe, the body politic took on a jurisprudential significance by being identified with the legal theory of the corporation, gaining salience in political thoughts from the 13th century on. In English law, though, the image of the body political development and the theory of the king's two bodies and the crown as what A1 said, corporation soul. And a corporation soul is what? A natural person. There you have the incarnation of Christ. All right. So with that, any questions on the floor? Any questions? Please hold, state now or forever hold your peace. Any questions? Is that your last name, Brother Dubbing? Is that your last name? I think you said it was William. The last name was William, right? Yeah, RSP. I wish you can get in touch with them brothers so they can come build with me. All right, but I doubt they want to do that. You know what I'm saying? So if you can get in touch with them, you know what I'm saying, and to speak about who they claim to be. All right, not from a biblical perspective, from a historical perspective. Okay, but I don't want to go into the Bible because Bible is just an abstract. Yeah, it's Williams. Okay, the Bible from an abstract talk is hearsay. We look at the Bible from concrete. All right, and based upon those who wrote the Bible and based upon their positions to have the authority to write the Bible based upon instructions, because that's what the Bible stands for. Believe in instructions before what? Leaving the earth. Okay. So do you got any uh uh way to get in touch with the ISUPK or anybody for that matter, Brother Williams from the House of Williams, in regards to setting up some type of platform where we can get together and break bread? Do you know anybody? And thank you, Brother McGarrell. No question. I know you don't, as long as you've been here. Brother Williams, if you can look into that by setting up something with the ISUPK, or Sign at a TV, or the House of Awakened Minds, or the Canaanite Moors. If you're able to connect with them, please set some up. I would very much appreciate it. All right. So with that, I'm going to greet you as I always meet you, and that's as well as in peace and love. Talk to you later, my brother.